Today, Rebecca and I are going to be talking about how the Pump Act potentially impacts your workplace. The Pump Act was just recently effective, and it expands the number of employers who have to comply with it, and it also extends protection to more employees. Welcome to Off the Clock, the webcast of employment attorneys at Miller Johnson, where we discuss what is happening in the HR world and provide practical insight and advice. Well, today we're starting another two-part series on two laws, right, that Congress passed at the end of 2022. But one of which just recently became effective, known as the Pump Act, and a second law called the Pregnant Workers Fairness Act, or the PWFA, that will be effective near the end of June.
These two laws are going to impact your workplaces potentially quite significantly.
Right. Yes. There's a lot happening, right, with regard to pregnancy, childbirth, and then employees returning to work from either of those. But today, for the purposes of today, we're going to focus just on the Pump Act.
Right. And let's just start first by talking about who needs to pay attention to this.
That's right. That's right. And to talk about that, right, I think it's important to first talk about what protections were already available to employees before the Pump Act, right? Because there were already some protections in place, weren't there?
Yes, and I'm gonna jump the gun just a little bit. I'm sorry, and take things a little bit out of order.
Okay.
Because the protections that were in place before the Pump Act only applied to employers of 50 employees or more, right? And one of the things the Pump Act does is expand it to employers of all sizes.
Right.
So if what we're about to talk about now sounds unfamiliar to you, and you say, wait a minute, I didn't even know there were protections in place already for breaks for nursing mothers.
Right.
And you're a smaller employer, that's probably why. But don't turn off, right, the podcast or the computer right now, because the new act also applies to you, but you're starting kind of behind the eight ball, right? Because you not only is it expanded, but you didn't know what was there
in the first place.
Yes, right? So, and we're going to talk more about other changes the Pump Act makes, but let's at least remind people, right, who might, again, be smaller organizations who are listening to us.
Right. So let's go back to 2010.
Yes.
Right? 2010 is when changes were made to the federal wage and hour law, the Fair Labor Standards Act, right?
Yes.
To provide certain requirements for employees who had a need to pump, right, or express breast milk when they were at work.
Right. Either phrase is fine, by the way. So some people, get kind of tongue-tied when they need to talk about either expressing milk or pumping is a fine way to talk about it in the workplace. And yes, in 2010, my favorite law, the Fair Labor Standards Act was amended to require two things: break time as well as a place to express milk or to pump. So let's break those down into the two categories.
Sure.
Neither one is very complicated, frankly. Break time, employers, again, of 50 or more, had to provide employees who had a child who was a year or younger reasonable time to express milk, reasonable break time.
Got it.
It only applied to non-exempt employees, and the breaks for expressing milk could be combined with existing breaks already or pre-existing breaks. So they didn't have to be additional breaks on top of other, like let's say the paid 20-minute breaks or a 30-minute unpaid meal break. So that's the basics of what the law required in 2010.
And are those breaks paid or unpaid?
They could be unpaid.
Okay.
But if they were 20 minutes or under, generally breaks are paid under the Fair Labor Standards
So
Act.
the same rules about breaks applied to these particular breaks for nursing mothers.
Right.
Yes?
Yes.
Okay, I see.
And the biggest question we got there was, what does reasonable mean?
Of course.
And I'm here to tell you that's why, right, we have That's how we stay in business,
Right.
is by lawmakers writing laws like that say reasonable without a lot of, without fleshing that out. In my practice, I don't know about yours, it really hasn't caused too much conflict, has it, in your practice?
I would say, that law doesn't enter my world particularly often. I don't get a lot
Right.
of questions on it, but when I have, it was exactly what you're saying, which
Right.
is an employee who's taking a significant amount of time,
Yeah.
right, to pump or to take these breaks, and a concern about whether or not it's potentially being abused or whether or not it's reasonable, et cetera. And exactly, the law doesn't define what reasonable means.
Right.
And I don't know about you, but in law school, they didn't teach me what is reasonable for an employee to express breast milk either, right?
Well, clearly we did not go to the same law school, which is true. We didn't, because my oldest was born while I was in law school, and I
so
was
you
given
did learn,
breaks
yes.
to pump in law school. However, I did not get credit for learning how to do that.
I see.
How to
I
take
see.
reasonable
Yes.
breaks and
Yeah.
what. So what happens, right? They typically, someone will ask a woman, right, who has nursed and who has pumped, what is
What's
reasonable and what
right.
is not, particularly men or women that haven't been through that experience. But every woman's experience can be different, so you do
course.
have to be sensitive to
And
that.
take that into account.
Yep.
Right.
In 2010, the bigger question that came up was the second part of the requirement, which is the space.
Yes.
Right? It has to be a space that is appropriate for pumping, that has a door that locks, but it does not have to be a space that is only used for pumping, right? And so that was the big question that we got, and a lot of people didn't realize that it could be a multi-purposed break room or something else. But it does have to be private when the nursing mother needs
see.
it, with a door that locks, and not a bathroom stall, right? So something
Not a
other
bathroom
than
at
a
all,
bathroom.
right? It
Yeah.
cannot be in a bathroom.
It cannot be in a bathroom for sanitary reasons, right?
Got it. Okay. So that makes sense. So it's got to be a space that can be used for other reasons, but the employee who then is using it to pump needs to have sole access to the space when she's using the space, right? So
Correct.
you can't have employees needing to get in and out, et cetera. The easiest way to accomplish that, yes, is with a door that locks to ensure privacy.
Yep. And if you do not have, never have, and don't have now, an employee that needs a nursing room, you don't have to create one right now. You just have to make sure there's one in place and ready to go
I see.
when someone needs it.
So best practice would be to have a plan
Yes.
that you can implement fairly quickly if that need arises, but you don't have to create this space and have it sit there potentially unused
Right.
if you don't need it right now.
Yeah. Okay. And for any employer 50 or more, of course, this is nothing new. This has been since 2010.
Okay.
So it's our smaller employers, right,
Got it.
who are hearing this for the first time, and it's our smaller employers who, frankly, may have less space, right? They don't have rows and rows of offices.
Sure.
Right, where they can just turn one into a nursing room.
I see.
So for those employers that are listening, it's okay if you don't have anyone coming back from a maternity leave, right, who's going to need a nursing room. You don't have to create the space immediately. But yeah, good thing to have in mind. And frankly, it could be a nice multi-purpose room that your employees would enjoy anyway, right? You may want to just create the room to be ready, a nice quiet space. I find people wanting rooms like that to take cell phone calls, et cetera, on their breaks, right?
Okay.
It could be that sort of space. Okay, so that's where we were at.
Right. So
in
let's talk
2010.
about then the Pump Act. So first of all of the things we just talked about that happened in 2010, all of those protections are still present.
Absolutely.
Right? Same language about the break time, same language about the space. The technical requirements have not changed. What has changed is first, which businesses have to comply with those requirements, right?
And that's a big change.
Yeah, so in 2010, that law had a very broad exception for businesses with fewer than 50 employees, right?
Yep.
That has changed now to say any business, so long as it's subject to the Fair Labor Standards Act, which is a very low threshold.
We're not going to get into that.
Yes, no, we're not going to get
Just
into
assume you do.
But it's
Yes.
it's a very low threshold.
Talk to me if you think you might not, but
Yes.
assume that you do.
And it does still have an exception for businesses with fewer than 50 employees. However, those businesses with fewer than 50 employees now have to demonstrate that it would be either an undue hardship or a significant difficulty or expense to comply, right? So we can imagine some smaller businesses might be able to meet that standard, meet that threshold, but it's not automatic.
Right. Yeah, so
Right?
you're going to have to come up with a good argument, and that's something you should touch base with legal counsel on. If you get a request, right, and you think that you might meet that standard of it being an undue hardship burden, you should call your favorite employment lawyer and talk that through.
Right, and we can think of examples of smaller businesses for whom providing break times or a space could be an undue hardship. For example, maybe a convenience store that only has one clerk working at a time, right?
Yeah.
The idea of having to shut down the entire store in order to allow that clerk to take a break could rise to that level. But it would be the business's burden to have to prove that.
Right, exactly.
So, yeah, so for our listeners, let's call them our smaller business listeners with fewer than 50 employees, I just really want to make sure they take away this idea that these are potentially new requirements for them. So the second thing the Pump Act changed is that the 2010 law, interestingly enough, did not apply to exempt employees.
Isn't that weird?
And I'll be honest, I'm not even sure all businesses really realized that, or even if they did, only applied those rights to non-exempt employees. It's sort of awkward to say to exempt employees, but not you, right? You're not allowed to take a break during your day to pump or use our space. It's kind of silly.
Because that's not typically how exempt workers work, right? They're usually not tied to their desk. They can
Correct.
usually come and go with a little bit more flexibility,
Right.
As long as they get their work done.
Yes.
That's almost not for every exempt employee, but for many, that comes right with their job, that flexibility.
That's right.
That had never been an issue in my practice. I don't know about you, it never once came up since 2010 that an exempt employee wanted a break and the employer didn't want to give it to them for whatever reason. It caused some conflict.
Yeah, the only time it's come up for me, honestly, is a dispute in which an employee was alleging that the employer hadn't provided her the sufficient break time or space, and it turned out she was exempt, right?
Right.
Which solved the problem in the moment, but not anymore.
Right.
That's exactly right.
That was in 2010 that solved the problem.
That's exactly right.
So how was it changed?
So the Pump Act now just does not have that exception for exempt employees. So now these protections apply to exempt employees just like they have for non-exempt employees since 2010. Exact same protections as we discussed. So exact same breaks, exact same space. For exempt employees, technically the break can be still unpaid, but I just struggle to think of a circumstance in which many employers would be interested in trying to make a salary deduction for pumping breaks. And I also, let me throw that back at you because you're the wage and hour expert. There are only a limited number of circumstances in which we can make deductions to exempt employee salaries, right?
Right, and that's in a different part of the Fair Labor Standards Act than where the Pump Act resides. So you have the Pump Act, which says exempt employees are entitled to these breaks and they do not have to be paid. But then you have the different part of the Fair Labor Standards Act that says most, not all, there are different ways to pay exempt employees, but most have to be paid on a salary basis, which means there cannot be deductions from their guaranteed weekly salary, except for very specific exceptions. And it's not listed as an exception there. So because it is all part of the Fair Labor Standards Act, I think employers would be safe if they really didn't want to pay exempt employees for those breaks. But I think there is some risk there. So I am thinking, I'm just frankly, right now, imagining conversations with the clients I talk to day in and day out, I can't imagine many would be interested anyway in not paying exempt employees for breaks to express milk. You have a good argument if you want to, right? But you might want to tread carefully. This is also a good time to mention another option that I think a lot of employers don't think about with
I think I know what you're
exempt
going to say
employees.
because you love this. You love this option.
I do. I love it because I know something that a lot of people don't know.
Right.
So it makes me feel good.
Right.
This is not new, by the way. We just find day in and day out, year in and year out, we get this comes up over and over again, and many clients don't understand. And it's the concept of PTO and how that interacts with exempt employees. The Fair Labor Standards Act does not care what part of that weekly salary is what you would consider in your pay stubs when you're running payroll, regular pay, and what amount of it is PTO.
I see.
So on your pay stub when you're running payroll, those are two totally separate categories. And we see regular pay, the salary may be less than the guaranteed salary, but as long as the PTO makes that up, such that the gross is exactly the same
they don't
as
care.
it would have been, the Fair Labor Standards Act is just not concerned. And so you could, if you wanted to, if you wanted to keep track of your exempt employees and how long their breaks were taking and say we're not going to pay for them, you could, as a middle ground, require employees to use PTO to cover the breaks. The reason I gave that whole prologue is you could use that in other circumstances too. And a lot of clients don't realize that.
Right. So if there are concerns or a desire to somehow count breaks for exempt employees against their salary, your proposal would be think about maybe having them use their available PTO time to accomplish that.
Correct.
Otherwise, it would also be fine just to continue to pay them their salary while they take these reasonable breaks. Let's be honest, exempt employees take breaks all the time without employers spending a whole lot of time worrying about whether they need to make deductions to their salaries, right?
All the time. Yeah,
So-
I mean, not all the time. But then we have another issue, and we could talk about that in another episode, maybe keeping track of exempt employees' time. That's a whole episode in and of itself. But you're right. With exempt employees, no one's keeping track of their ins and outs, right? Their breaks during the
So
day,
if
how
these
long their
are
lunch
reasonable breaks, it also would be fine just to continue on, let them, allow them to take the breaks without issues, provide them the space, et cetera, just like you do others.
Exactly.
Again, I suspect many of our listeners with more than 50 employees already are hearing what we're saying and are thinking to themselves, we already do this for exempt employees. We have since 2010, which also is just fine.
Absolutely.
But if somehow you were making an exception, don't do that anymore now. You have to provide it.
Yep. And because exempt employees are now covered by the Act, employers that restricted nursing rooms to just non-exempt employees and said exempt employees keep out, you have to take down those signs.
Yes. Right.
And allow exempt employees.
Great
to
point.
use-
Yes. Thank you.
We are
Thank you.
solving the world's problems today, sir.
That's right. Okay. So the third change from the Pump Act relates to remedies and actions that an employee can take if their rights have been violated under the law. Before the Pump Act, there was not a private cause of action, meaning employees did not have the ability to directly sue their employers if their employers were not complying with the 2010 Act.
Okay.
That now has changed. And I do think this is an important change. Now there is a private cause of action, meaning employees can file lawsuits and allege damages, including liquidated damages, which is a fancy legal term for double, right? If a covered business does not provide the reasonable breaks or the space. Okay, so listeners, what you should hear is we can get sued.
The risk level has gone up.
the
for
risk
getting this wrong.
level has gone up, and there's all sorts of damages available: lost pay, liquidated damages, punitive damages, etc.
The one that I know the one that you think is the most problematic,
Which is what?
constructive discharge, right?
Yes,
So,
I was going to say, the way I see this playing out, this is just my best guess, but the way I see these legal claims probably playing out would be an employee who resigns, who leaves her job because she is not being given the reasonable break times or a reasonable space
Yep.
to pump. Now she can file a lawsuit, a constructive discharge claim against her employer, alleging that she had no choice but to resign because of that, and claim lots and lots and lots of damages.
Yes.
So this is no longer just a Department of Labor investigation. This is a lawsuit involving real money. So that is the Pump Act.
Thank you so much. This is going to be so helpful to so many people, especially our smaller clients.
And next time, we're going to be talking about the Pregnant Workers Fairness Act, or the PWFA, and talking about how that changes the landscape for accommodations of pregnant employees.
Significantly. So we hope people tune in for that one.
Exactly.
All right. Goodbye, Sarah.
Bye, Rebecca. Thanks.